turnout tonight. It's good to see you.
Really?
With such interest. We're going to try and cover all of Section 1 today. I don't know if we'll even make it through, but I got 9 pages of notes, just of incidentary information, background stuff that I found interesting. Hopefully you will too, in addition to the different sections. And then if we have, I don't know if that'll take up all our time, if we have time to go through the whole section, but we'll try. It's really interesting. It's got a lot of, it's loaded with information. So we'll start with Article 1, Section 1. Well, first I'll just start with the preamble.
Yeah.
It's pretty important too. Starts out, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So here he's defining that we the people are in charge of this, not the government's not in charge. We the people, it's our Constitution, we're defining it. And to form a more perfect union, to have a cohesive national government that can hold the 13 colonies together. Establish justice, and that's all these others they define in detail in the articles, and we're going to do that as we go through it. One of the big sticklers up here is promote the general welfare. What does that mean? And we'll discuss that in some length, tonight in Section 1, in Article 1 rather. Okay, Article 1, Section 1, and that's basically the first paragraph here. It says, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Now the Constitution established 3 separate branches of the federal government: federal, legislative, and judicial. It's the first time that's been done in the history of mankind. They had those 3 before, but every government combined them somehow into one. Either legislative and judicial were in one, or executive was established as a result of the legislature, not the people, and different examples of different governments. But we are the first one that separated all 3. The Founding Fathers, again, were students of history as well as students of mankind and human nature. And they studied all the various republics that had existed to their knowledge in history. Starting back with the Greeks, the Romans, contemporary Italy and Europe, and learn from them what worked, what didn't work. And one of the things they saw that did not work was combining these. Whenever you combine any two of the three, tyranny existed. They strongly believed that, so that's why they separated, the 3 branches. So it says, superficially, one might think it was a matter of chance as to the order in which each branch would be outlined and defined, and it wasn't. I think to all of them, they felt that the legislative branch was the most powerful of the 3 branches. They weren't all equal. They were separate, but by no means were they equal. They never felt that they were equal, and it never states anywhere in the Constitution that we have 3 separate and equal branches. It's that we have 3 separate branches. So, because the legislative branch was the most powerful, being the voice of the people, and the most powerful in the history, it's always been the legislative branch that controlled things. That's why it's the first one they address. And they talk, and then they break it up into the House of Representatives and the Senate, discuss each of those. Said they did not write it without careful reference to the prior scholarship of great men, and without reference to the history of all prior Republican forms of government. James Madison of Virginia particularly, drawing heavily upon materials sent to him from Paris by Thomas Jefferson when he was abroad, made certain that the Constitution evolved from the past experience of all the republics that had failed and would not be written out, as was later to be the case with the disastrous French democracy or Constitution, as an act of constructivism, rationalism. John Locke's seminal book, The 2 Treatises of Government, is the book that provided the intellectual justification for England's revolution back in 1689. It provides a rationale for putting the legislative branch of government at the very beginning of the Constitution. In there he says, the great end of men's entering into society, being the enjoyment of their properties in peace and safety, which is the reason you have government, and the great instrument and means of that being the laws established in that society. The first and fundamental positive law, which is to govern the legislature itself, is the establishing of the legislative power. This legislature is not only the supreme power of the Commonwealth, but sacred and unalterable in the hands where the community, that's the people, have once placed it. Nor can any edict of anybody else, in what form soever conceived, or by what power, serve or backed, have the force and obligation of a law, which has not its function from that legislative which the public has chosen and appointed. They didn't talk any clearer back in 1689 as they did, in the 1700s either. So it's pretty hard to understand a lot of that. But again, he's reinforcing the need to have legislature as the prime means of government. They determine the law, so they speak for the people, the community. So it's without a doubt the most important. The decision to separate the three branches was by no means set in stone when the convention first assembled in Philadelphia. James Madison in particular was deeply impressed by the 1765 commentaries of William Blackstone, a noted English lawyer, I guess, jurisprudence, and politician, who favored a single unified branch system. Following up on this argument, Madison, while awaiting the arrival of several other delegates, etched out a Virginia plan that envisioned one branch only, the legislative branch. This branch would be responsible for appointing the executive and the judiciary, although these legislative agents jointly would be empowered to veto legislative decisions under certain circumstances. So the legislature would have the power to pick who they wanted, so they had less chance of getting vetoed, obviously, so it gives them a lot of power. He says, however, even such vetoes would be subject to legislative override by some unspecified supermajority, much the same as we have nowadays with a two-thirds vote. They can override a veto by the president, which we'll cover. According to the Virginia plan, there are to be two chambers of the legislature, a bicameral legislation, the House and the Senate. Each state would be represented in each chamber in proportion either to its financial contributions or to its number of free inhabitants. The small states perceived that such an arrangement to constitute an inordinate threat to them, because they didn't have the power, they didn't have the people, so they were going to be outnumbered. So they, in the Connecticut Compromise in 1787, what they did is they basically countered this, and they abandoned the Virginia plan in favor of a bicameral legislation in which the lower house, that's the House, would be based on population, and the upper chamber, the Senate, much the same as it, would have equal representation. In reaction to this compromise, Madison then etched out an ultimately successful case for separating the three branches as added checks and balances against the greatly feared forces of faction. Now the question whether the legislature should be comprised of either a single chamber, or unicameral, or a bicameral was far from resolved again at the outset of the convention. It wasn't a foregone conclusion. When George Mason proclaimed to the delegates that the mind of the people of America was well settled in its attachment to the principle of having a legislature with more than one branch, he was not truly asserting that the matter was beyond contention. 11 of the 13 states enjoyed bicameral legislatures. However, the Continental Congress consisted of but a single chamber, and Pennsylvania, who was host of the convention and the home of the first American, Benjamin Franklin, operated with a unicameral legislature, so they carried a lot of weight. In Section 2, he defines the House of Representatives as shall be composed of members chosen every second year by the people of the several states, and the electors in each state of the qualifications requisite for electors of the most numerous branch of the state legislature. So there they're defining that who's qualified, how often they run. As we discussed in the Federalist Papers, they figured the prime reason for the legislature and electing the people there was to have people who were familiar with the basic laws of the land in the various states, and they could write an overriding laws that would combine those and unify them as need be. They weren't involved with treaties and those things of national significance, that's what would be the Senate. So they could come up to speed rather quickly. So a 2-year term met the fine line between too short a time period and waiting too long for the people, but it gave them enough time to be effective in learning what their job was and to do it. So that's why they settled on the 2 years. Because it was representative of the people, they wanted them to have the shortest or the most frequent opportunity to re-elect. If people don't like what they're doing, they can throw the bums out. So that's the reason they had for 2 years. The electors in the state, again, qualifying for the electors, that's just saying you had to be a qualified elector within the state because the state's electing the representatives. You know, again, a common sense rationale. Section 3 talks about no person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Again, they're talking there again at the 25 years, they're mature enough, they've been around, they've got some history that people will feel comfortable they can be good representatives for them. And being 7 years a citizen, back then did not mean a natural citizen, it just meant a citizen. They could be naturalized as we know it now. They didn't define what a citizen was. That was defined within the states at the time of the writing. Each state defined who a citizen was, and it was not uniform. They made it uniform later, and we'll be discussing that here as well. Come on in. We just got started. Article 1, Section 1. Then they talk here about representatives and, rather the Constitution, representatives and direct taxes shall be apportioned among the several states which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole numbers of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. That's where the 3/5 persons is defined. That was later changed in Section 2 of the 14th Amendment. In April of 1783, you notice this was 4 years before the Constitution, in the Confederation Congress, the 3/5 compromise emerged after 6 weeks of debate. So that concept had been around and discussed for a number of years. An 8th article was proposed for the Articles of Confederation, apportioning expenses for the Confederation on the basis of land values as surveyed. There, the discussion opened only to reveal how difficult a topic it was to assess land values. And in the rude conditions of those times, to produce accurate surveys, thus they resorted to numbers instead, speaking of population as a rough supplement. Instead of picking the land values, they could count people a lot easier. Taking the numbers of people in the respective states, they hit upon the following language. Expenses shall be supplied by the several states in proportion to the whole number of white and other free inhabitants of every age, sex, and condition, which would include blacks, whites, browns, any colors whatsoever, including those bound to servitude for a term of years, and 3/5 of all other persons not comprehended in the foregoing description, except Indians not paying taxes in each state. So very similar, the wording is very similar, but it's not exactly the same. So what does the 3/5 apply to? Slaves, carefully and legally defined. But reading the opening clause, delimiting, quote, the whole number of whites and other free inhabitants. Now that doesn't apply to whites only, nor to males, since every age, sex, and condition is further appended. You know, in the Confederation, in the Articles of Confederation, it says of every age and condition. In the Constitution, they changed that just to be less verbose, to be, shall be to the whole number of free persons. So it doesn't go into as deep an explanation in the Constitution. Clearly they aimed at every free human being, white and non-white. As is generally known, the only significant number of free non-whites in the United States in 1783 were American blacks, another 10,000 of whom were free. You know, were emancipated between 1776 and 1787. They don't explain that in their history, do they? There were not in the United States of 1783, for example, any Asians. Thus, those legislators included American blacks among the free inhabitants. The following 3/5 clause applied not to blacks generically, but rather to persons in the particular legal category of slavery, which included whites. There were a number of whites that were slaves. 3/5 of the number of slaves were counted, not in terms of their humanity, but with respect to their legal status in the respective states. Again, that was a trade-off, again, with the southern states, because just the head count, there were so many slaves down there that would really up their power, because they would get more representation in the legislature. And people, to quote the free people in the north, free persons in the north and the west, and didn't think that was strictly fair to them. They were paying all the taxes and not getting the benefit of the representation. So you got all the money coming in from the north and the taxpayers, and then the people from the south want to include the slaves to get equal representation to the people in the north, but they would be, quote, paying their fair share. So that was the argument that was going back and forth for years. The Confederation Congress fully affirmed that humanity of American blacks through the language of white and other free inhabitants. So that included blacks. And that was a recognition of humanity. Withdrawal when the same language was taken up again in the 1787. No. Representations and direct taxes shall be apportioned among the several states, which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons. Again, free persons includes age, sex, color, in any way you want to describe it, including those bound to service for a term of years. That would also include indentured people, but excluding Indians who were not taxed, and 3/5 of all other persons. So a little broader definition, but people nowadays are defining that rather closely to suit their own political needs and ends. The lapse of 4 years has brought changes, but what are the changes? On the surface, changes are primarily editorial, introducing economy and exactness of the language. And as any composition teacher would point out, the first thing to notice is the elimination of redundancy. Why should it be necessary to say the whole number of white and other free inhabitants of every age and condition when the whole number of free persons says the same thing? Further, adding 3/5 of all other persons at the end is less awkward than the inclusion clause of 1783. And finally, the substitution of service for servitude continues the liberal impulse of 1776. But it says nothing about who gets the rights to vote. Thus, 1787's freedom language includes women and blacks, does not exclude them. Then it goes on in the Article 1 there to talk about the actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States and within every subsequent term of 10 years. Therefore, the reason for our census constitutionally demanded. Number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, and it goes on to define setting for each of them as it stands in that day. When vacancies happen in a representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. So each state is responsible for providing replacements for anybody that resigns for whatever reason, or any vacancies that occur for whatever reason. So the state doesn't say the state governor, because all the states didn't have governors then. Some had presidents. Delaware, I think, had a president of the state. 2 or 3 states had presidents, others had governors, and others had some other definition. So they mentioned that as the executive authority, by whatever name it goes. They're not bound to that. The House of Representatives shall choose their speaker and other officers and shall have the sole power of impeachment. Again, it gives the gives the authority there to the legislating body to make its own rules, basically, and determine who their officers shall be. But they also have the sole power of impeachment. So any federal officer, up to and including the president, impeachment proceedings have to be brought by the House. They're the only ones that can do that.
Can they impeach federal judges?
Oh yes, they have.
Okay.
Most of the impeachments have been federal judges at whatever level, maybe district, but they only applies to federal officers.
Okay.
They cannot go into a state and impeach them. That power relies within the sovereign state.
Yeah. Okay.
But there have been something like, I forget the number we had. I left that paper at home. Probably 29, over 30 some impeachments altogether, and about 7 of them have been the presidents. The rest of them have all been, I think, not all of them, but the majority of them have been judicial. And about 15 of them have been removed from office or resigned from office or something. 15 or 18, I forget what number it was. Yeah.
Okay. Thank you.
But again, it has to be for cause. There has to be cause, which they define here too.
Yeah.
Said, at Philadelphia, the framers needed to remove the structural impediments to good government while simultaneously preventing governmental efficiency from malign use. I mean, separated, balanced, but also independent branches of government, each exercising one of the 3 powers, could prevent tyrannical government without preventing firm government. So that's why they were very specific in the wording and the way they separate everything. Section 3, we talk about the Senate. And first clause there talks about the Senate shall be composed of 2 senators from each state, chosen by the legislature thereof, which has been modified by the 17th Amendment. They're elected for 6 years, and each senator shall have 1 vote. Then they talk about, again, they should be assembled immediately in Congress, shall be divided as equally as possible into 3 classes, so that every 2 years, 1/3 of them can be up for election. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the 2nd class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year. So the 1/3 are chosen every 2nd year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until next meeting of the legislature, which shall then fill such vacancies. Again, that was changed also by the 17th Amendment, when we took the power away from the states. And we'll discuss that when we go through the amendments in more detail. Says today about 90% of the incumbents are re-elected in an average life cycle, election cycle. But at the time of the founding, incumbents were not as safe. It says a well-known fact that around half were not re-elected. So 50% were thrown out of office, or for one reason or another didn't run or whatever, but they did not return. Now, is that a problem? If you're turning over the legislature every 2 years, that means you have new people coming in. That means they're going to have their own way of doing things. They're going to rewrite the laws they didn't agree with that the last session wrote. So your laws are going to be constantly changing. Is that a good thing? If you're in business and you're trying to start up something, you don't know what the laws are going to be. You're going to be more inclined to go into business or not? Wait.
Wait a second.
It undermines foreign policy if you don't know what the laws are going to be, if there's no stability to it. It undermines the rule of law, which requires that laws be settled and known to everyone. It gives an unreasonable advantage to the sagacious and the enterprising and the moneyed few over the industrious many. This is because changes in the law will be known and tracked by the wealthy, who will be able to take advantages of the new laws. Of course, that doesn't happen nowadays. It dampens entrepreneurship. Who would be willing to consider again new business opportunities if there is concern that the government's laws may change tomorrow? We're going through that now. We don't know what the laws are going to be, or we don't know what's going to happen. When the laws are constantly changing, citizens, and this is probably the worst of them all, our trust in the government fails. We don't have faith in the government. and faith in their representation is reduced. So the less faith you have in them, the more apathy you're going to have. People are not going to want to participate in the government. And it's the worst effect of unstable laws produced by unstable legislatures. So that's the reason that they came up with 2 years for the House, 6 years staggered for the Senate, and also 4 years for the presidency. But as far as the legislatures are concerned, that's one of the 5 major reasons that Madison gave. Let's see. They go on to talk about the qualifications for the Senate, again, reaching 30 years rather than 25 years, and 9 years as citizens rather than 7 years for the House, and shall not, when elected, be an inhabitant for the state to which he's chosen. Again, the senators are assigned more the duties of working with foreign treaties, working more long-term nature, and being a stabilizing force with the legislature. Where the House is elected every so often, it's going to be a more boisterous community, much like in England, where the lower house is a much noisier and boisterous crowd than the House of Lords, who's above it all. You saw the same thing applying here by you're going to have more people, a little more maturity, a little more time on their belts. They're more seasoned, and they're going to be picked for that reason as well. So they're going to have more time in their positions at 6 years to provide that stability to the laws that are written. We haven't necessarily seen that maturity exhibited all the time in the Senate, but that was the rationale for it. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. Rather think it's not a very important clause, but actually it is. Cheney, for instance, exercised it 9 times, one of which the tax cut laws. He was a 51 vote because it was tied 50-50, and there was another one where he did it, I forget which one it was now. The Senate shall choose their other officers and also a president pro tem in the absence of the vice president, or when the vice president exercises the office of the president of the United States. And we've seen that in our lifetime when vice presidents have had to assume the presidency. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. So the House can bring impeachment proceedings, but it's tried in the Senate. And the Senate provides its own officers, except in one case, the presidency. In that case, the presiding officer is the Supreme Court judge, the Chief Justice. And again, 2/3 votes to impeach him. Judgment in cases of impeachment shall not extend further than to remove from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But if the party is convicted, they are also nevertheless liable and subject to indictment, trial, judgment, and punishment according to law. So they can still face civil proceedings. Does not exempt them from that. So no such thing as double jeopardy from impeachment. Section 4.
We have a question.
Sure.
So with the Senate being voted on, is the legislature, they get together and they say, let's vote McCain as a senator, right? And so then, okay.
State legislature. This time.
Say it again? No.
You were talking about the Senate?
I'm talking about the Senate.
Yeah.
I'm trying to understand how a Senate is established.
Okay. They're elected by the state legislature, not the individuals, up until the 17th Amendment. That's how initially, that's how they were elected.
Right. So the state chooses their Senate.
There are two of them, yeah.
Right. Okay, so not the federal.
No, it's at the state level initially.
Okay, so the state chooses their senator.
Correct.
Okay, that makes more sense.
That was another balance and a check on the Senate that gave the states again some power.
And then the Senate's deal with the feds. senators
the
deal
feds?
with the feds to protect the state. Like if, like on,
When you say they deal with the feds, I'm not sure I know what you mean with that. I mean, they enact legislature, they pass legislature that the House has passed. So they generate and pass legislature for the president to sign to put into effect. They deal with treaties, foreign treaties, they have to ratify them. They have to ratify appointments by the president for different offices. So they have specific jobs which they are assigned in the Constitution, or specific responsibilities.
You're asking how they got the federal, the.
because we have state senators too.
Correct.
And then we have
Right.
federal senators.
But in the
But
beginning, it wasn't.
Each state has their own government set up by the state.
Right.
Some are bicameral, some are unicameral, some don't have a House and a Senate. Pennsylvania, for instance, didn't. They had one body.
Well, I didn't know that.
Yeah,
It's Commonwealth.
yeah. Commonwealth of Pennsylvania. So that's the way that they were set up. So they weren't all the same, and the federal government cannot dictate to the states, you're gonna set it up this way. Each state is sovereign unto itself.
So state senators and federal senators are right now, is just because of the 17th Amendment? Is that what's happening?
Well, the 17th Amendment, what that did is it took the power away from the Senate. The senators are no longer elected by the state legislatures, they're elected by the people, the same way as the House representatives are
right.
elected by the people in the election. So they made it a popular vote. So it took power away from the state as a body, as a governing body. The states lost a lot of authority, because who was looking out for their interests in the past? Before the 17th Amendment, the senators who, hey, that state legislature picked me for this job, I'm sort of beholden to them. They're not beholden to the states now. They could care less if the governor and the legislature, if they agree with them or not. They don't care. They're more concerned about getting reelected, and state legislatures not elect them. We the people are. So that's how the 17th Amendment changed everything drastically. It's a big, big change. The Senate still has the same responsibilities. That did not change. It's just how they were elected and who they're beholden to.
Okay, so we have a Congress, right, at the
Bicameral
federal level,
Congress.
and we have a Senate at the federal level.
You got House and the Senate. Congress includes both, House and Senate. When you say Congress, that's both of them.
Okay.
But you have a House and a Senate, right? And now they're both elected by the people and
Right,
elections.
and before the 17th Amendment, the Senate was elected by the state legislatures?
Correct.
Okay.
And each state did it a different way. They may have appointed them, they may have, I don't know how they did it, but they didn't have to do it the same way, because each state made its own determination on how they would pick their senators.
All right, that's fine.
Okay.
Gotten better. Still gonna work out a little bit, but okay.
Feel free to ask questions anytime, pop in, you know. It's not a lecture, it's better to get questions.
The senators approve presidential appointments,
Correct.
except when he does it
We'll get into
out of
that.
order.
Well, they have to do it if they're in session. So that's the key, if they're legally adjourned. That's the issue that we just faced recently. They weren't adjourned. So really what he did was
But he got away
unconstitutional.
with it.
Well, that's up to us. That's just,
That's
Constitution
up to
just.
our representatives.
It's up to us. The Constitution is just a piece of paper. It's only as good as we, the people, let it be. Not our representatives, that's passing the buck. It's we. We elect them, we can vote them out. The ones that let this go, are we gonna re-elect them next time?
Nope.
I hope not, but I've said that before too. And a lot of them have been in there a long time, 30, 40 years, and we don't like what they're doing, but they're still in there.
I'm old fashioned, never vote for an incumbent.
I like that. Any other thing?
Kathy had a question.
Well, I was hearing what he was asking. They didn't take some of the state legislatures and send them to Washington.
They couldn't, no.
They could not do that. They just selected the people of the state they thought were worthy of that.
In much the same way that they didn't elect the president and vice president the way they do nowadays either. State legislatures elected electors, and those electors all met at the same time, and they wrote down the names of 5 or 7 people that they wanted to be president. And that's how the president was selected. President was number 1, vice president was number 2. There's no running on a ticket. They didn't have Republican, Democrat then.
Now, that wasn't the Electoral College as such.
Did that exist
It was
then?
just a,
No, that didn't exist then.
interesting.
Yeah.
So what stopped corruption?
What stopped corruption?
Yeah, I mean,
At what level?
so it's, okay, so the legislature would pick their senators. Okay, so let's say it's all a Democrat and they're all criminal with their own agenda like we just had. They're gonna pick senators that are gonna contribute to that, right?
Yes. Much the same as if they're all crooks, like they're saying, then we the people keep electing them back into the same position. We must like the job they're doing. We like their crookedness. So why should we complain about the people they're selecting to send to Washington? They're gonna be just as crooked in our favor.
So why is it better, so then why is that better than us voting for senators?
Nothing to do with corruption, more a matter of whose interests are the senators looking out for. If the senators are picked by the state legislature, that's who they're going to try and protect. When they write laws, it's going to be with their state in their best interest, rather than taking it down to the next level to the people. They really don't care about the people as such, because the people aren't the ones that elect them. They want to get reelected, so they're going to be trying to satisfy their constituents being the state legislatures.
So if they want something like this railroad thing that's going to bankrupt the state, the senators will say, no, that's going to bankrupt the state. And even if people say, no, come on, Senator, vote for it. No, it's going to bankrupt the state. They would stick to their guns on that, because that's going to help the state stay more viable, right?
If the state legislature wanted it, and that's the word they're giving their senators, I would hope that they'd vote the way their legislatures want them to vote, yeah.
Okay.
That's usually the way human nature works. You want to stay in office, you make your constituents happy. And because their constituents, again, are the state, it gives the state more power in dealing with the federal government. Now, they've lost that power, the state has. So when you're talking about all these things coming down the pipe from the federal government, the state really has nobody looking out for their interests, and they keep getting all these taxes added onto them, and new restrictions added onto them, regulations, and they don't have anybody looking out for them.
When the states selected the senators, didn't the states have the right to recall a senator and put somebody else in there?
No,
They didn't?
the Constitution doesn't allow that.
They were selected for a term.
Yeah, the Constitution says how long they're going to serve.
Okay.
They can be impeached, that's the only way you're going to get them out, you know, or they leave on their own. That's really only two choices, or they die. That's again leaving, yeah. Involuntary leaving, I guess. Some sort. Feet first or face first. Any other issues or questions? Okay. Section 4. Time, places, and manner, including elections for senators and representatives, you're just ahead of yourself there, before we get into it, shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Until 1842, Congress left regulation of such elections to the states. The states did not adhere to any single regulation or single standard of electing representatives. Senators were still elected by state legislatures. Often, at least some congressmen were elected at large. So within Florida, we have the state legislature, a House, and a Senate. There's a federal election for the House of Representatives, but the rules for it were written by the state. There were no federal mandate. Here's how you're going to do it. When you're going to do it, here's how you're going to do it. So they may say, okay, Florida's got 5 representatives. Okay, we're going to let Tampa and Hillsborough County, you select the next 5. That was in their rights to do that. It didn't have to be a statewide election. There was no standard. So, or it could be, like you said, it was an at-large. We didn't have our own representative. We had, like senators are at-large nowadays. Some of them, the House of Representatives were elected that way. Maybe all 20 representatives were represented or elected by the at-large status. So everyone in the state voted on everybody. Is that good representation? I don't like it, but I can move to another state. That's my choice as an individual if I didn't like it. It says in that year, Congress began to mandate the single-member districts be used. So that's 1842. So first, what, 50-some years, it was not regulated. But the Constitution gives you that the Congress may, at time of law, make or alter such regulations. So it gave them the authority to make or alter the existing regulations on how it's done. So it started exercising that constitutional right. By 1911, federal law mandated that such districts be, quote, composed of a compact and contiguous territory and containing as nearly as practicable an equal number of inhabitants. So that's when you started getting the zoning. Excuse me. When a later law eliminated the last requirement of composed of a compact and contiguous territory containing nearly as equal number as possible, substantial malapportionment occurred. Of course. Eventually, the Supreme Court waded into this political thing using another related provision, Article 1, Section 2, to strike down apportionment that resulted in districts of disproportionate populations. So I said, that's where the judicial came in and said that's in violation. What you're doing is in violation of the Constitution. So people have to be elected and have a right to representation. And so the judicial came and stepped in, made the correct decision at that point. And a nearly absolute one-man, one-vote equality emerged to assure nearly as practical one man's vote in a congressional election, which we have nowadays. State laws are still important. States still control recount, requirements for recounts, as a number of candidates in various close races in November 2010 discovered. As well, states have different rules and interpretations by state courts for replacing candidates who drop out shortly before the election. Frank Lautenberg of New Jersey was permitted to replace corruption-plagued Democratic Senator Robert Torselli on the ballot when the latter withdrew a month before the election, clearly in violation of their state laws. On the other hand, Texas Republicans were not permitted to replace Tom DeLay's name on the ballot when he withdrew 5 months before the election, and he still had the right at that point. So state laws do count, and states still can exert some authority, good or bad. I guess it depends on which side of the road you're on, as usual. Any questions about the elections and times and places? Section 5, each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner and under such penalty as each house may provide. One very real threat to the quorum requirement would come if a number of members decided to flee or otherwise avoid attending the deliberations of Congress so as to prevent a quorum and keep business from being done, much the same as happened in Wisconsin this last year. Imagine if our federal government could do that. I don't know where they'd run. I guess they'd have to leave the country to get out of the jurisdiction. But it's not a right that they have. Of course, this is occurring right now, as I say, and I think it happened down in Texas also and someplace else. I don't know if it happened in Arizona. Ohio, was it? That's right, yeah. The framers, says, effectively countered such a threat by allowing a smaller number of legislatures to compel their erstwhile colleagues to return. That's being the call for quorum. In the Federal Convention, John Randolph and James Madison proposed adding this requirement on August 10th, 1787, the day that the quorum requirement was debated in Congress. If effectively applied, it can prevent a minority takeover of the power of the national government through inaction. So that was a good thing to put in there. It prevented such an occurrence from happening at the federal level. Each house shall determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. This prevents one house from making cultural changes to another. So the House cannot make rules that affect the Senate and vice versa. Each of them have their own authority to make their own proceedings, make their own rulings up. For instance, the Senate cannot force the House to spend 4 legislative days on one bill. Similarly, the House cannot force the Senate to abandon the filibuster. Perhaps more notably, Article 1, Section 5, Clause 2, which is this one, also prevents a current Congress, and a current president for that matter, from binding the procedural actions of a future Congress. So they can make certain rules for how they do business this year. New Congress comes in, they can change it. They don't have to abide by the same rules, but they set up the rules at the beginning of each session and any time through the session. This point is critical to understanding legislation and the American political system. So no matter what any Congress and President enact into law, the fact that each House of Congress sets its own rules will always trump any law. Can you tell me why? Because the Constitution outtrumps any law, any enacted law. The Constitution as the supreme law of the land. Nothing trumps that. So no matter what law the President, such as health care, if it's unconstitutional, goes against the Constitution, it's invalid. The Constitution wins every single time. But therein comes a rub. Who interprets it? How do they interpret it? That's the problem we're having nowadays. And how do you get it in front of them? Can anybody do anything about avoidance of such avoidance of the rules? No, because each body of the Congress, the House and the Senate, the Constitution gives them that full authority to set their own rules and establish their own proceedings. So we can't change that. That's unless we do an amendment to the Constitution. That's the only way that can change. Much as as distasteful as it is, sometimes that's the importance of electing people to represent you, getting the right people in office so that they can have proceedings such that are fair and honest, the way we want them to be, and not crooked. That's where you get, and the more participation you have by the people. It's what it always comes down to, and that's what Madison and Hamilton preach over and over again in their Federalist Papers. We the people, we make the final determination. It's up to us whether we abide by the law of the land or not, at every level. It says there's neither check nor balance against either House of Congress ignoring its own rules